Pendleton Act of 1883, an act to regulate and improve the civil service of the United States, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the President is authorized to appoint, by and with the advice and consent of the Senate, 3 persons, not more than 2 of whom shall be adherents of the same party, as civil service commissioners, and said 3 commissioners shall constitute the United States Civil Service Commission. Said commissioners shall hold no other official place. Under the United States, the President may remove any commissioner, and any vacancy in the position of commissioner shall be so filled by the President, by and with the advice and consent of the Senate, as to conform to said conditions. For the first selection of commissioners, the commissioners shall each receive a salary of $3,500 a year, and each of said commissioners shall be paid his necessary traveling expenses incurred in the discharge of his duty as a commissioner. Section 2. That it shall be the duty of said commissioners, first, to aid the President, as he may request, in preparing suitable rules for carrying this act into effect, and when said rules shall have been promulgated, it shall be the duty of all officers of the United States, in the departments and offices to which any such rules may relate, to aid, in all proper ways, in carrying said rules, and any modifications thereof, into effect. Second, and, among other things, said rules shall provide and declare, as nearly as the conditions of good administration will warrant, as follows: first, for open, competitive examinations, for testing the fitness of applicants for the public service now classified, or to be classified hereunder. Such examinations shall be practical in their character, and so far as may be shall relate to those matters which will fairly test the relative capacity and fitness of the persons examined to discharge the duties of the service into which they seek to be appointed. Second, that all the offices, places, and employments so arranged, or to be arranged in classes, shall be filled by selections according to grade from among those graded highest as the results of such competitive examinations. Third, appointments to the public service aforesaid in the departments at Washington shall be apportioned among the several states and territories, and the District of Columbia, upon the basis of population, as ascertained at the last preceding census. Every application for an examination shall contain, among other things, a statement, under oath, setting forth his or her actual bona fide residence at the time of making the application, as well as how long he or she has been a resident of such place. Fourth, that there shall be a period of probation before any absolute appointment or employment aforesaid. Fifth, that no person in the public service is for that reason under any obligations to contribute to any political fund or to render any political service, and that he will not be removed or otherwise prejudiced for refusing to do so. Sixth, that no person in said service has any right to use his official authority or influence to coerce the political action of any person or body. Seventh, there shall be non-competitive examinations in all proper cases before the Commission, when competent persons do not compete, after notice has been given of the existence of the vacancy, under such rules as may be prescribed by the Commissioners as to the manner of giving notice. Eighth, that notice shall be given in writing by the appointing power to said commission of the persons selected for appointment or employment from among those who have been examined, of the place of residence of such persons, of the rejection of any such persons after probation, of transfers, resignations, and removals, and of the date thereof, and a record of the same shall be kept by said commission. And any necessary exceptions from said 8 fundamental provisions of the rules shall be set forth in connection with such rules, and the reasons therefore shall be stated in the annual reports of the Commission. Third, said Commission shall, subject to the rules that may be made by the President, make regulations for, and have control of, such examinations, and, through its members, or the examiners, it shall supervise and preserve the records of the same, and said Commission shall keep minutes of its own proceedings. Fourth, said Commission may make investigations concerning the facts, and may report upon all matters touching the enforcement and effects of said rules and regulations, and concerning the action of any examiner or board of examiners hereinafter provided for, and its own subordinates, and those in the public service, in respect to the execution of this act. Fifth, said Commission shall make an annual report to the President for transmission to Congress, showing its own action, the rules and regulations, and the exceptions thereto in force, the practical effects thereof, and any suggestions it may approve for the more effectual accomplishment of the purposes of this Act. Section .3. that said commission is authorized to employ a chief examiner, a part of whose duty it shall be, under its direction, to act with the examining boards, so far as practicable, whether at Washington or elsewhere, and to secure accuracy, uniformity, and justice in all their proceedings, which shall be at all times open to him. The chief examiner shall be entitled to receive a salary at the rate of $3,000 a year, and he shall be paid his necessary traveling expenses incurred in the discharge of his duty. The commission shall have a secretary, to be appointed by the president, who shall receive a salary of $1,600 per annum. It may, when necessary, employ a stenographer and a messenger, who shall be paid, when employed, the former at the rate of $1,600 a year, and the latter at the rate of $600 a year. The commission shall, at Washington, and in one or more places in each state and territory, where examinations are to take place, designate and select a suitable number of persons, not less than 3, in the official service of the United States, residing in said state or territory, after consulting the head of the department or office in which such persons serve, to be members of boards of examiners, and may at any time substitute any other person in said service living in such state or territory, in the place of anyone so selected. Such boards of examiners shall be so located as to make it reasonably convenient and inexpensive for applicants to attend before them, and where there are persons to be examined in any state or territory, examinations shall be held therein at least twice in each year. It shall be the duty of the collector, postmaster, and other officers of the United States, at any place outside of the District of Columbia, where examinations are directed by the President, or by said board to be held, to allow the reasonable use of the public buildings for holding such examinations, and in all proper ways, to facilitate the same. Section 4. That it shall be the duty of the Secretary of the Interior to cause suitable and convenient rooms and accommodations to be assigned or provided, and to be furnished, heated, and lighted, at the city of Washington, for carrying on the work of said commission, and said examinations, and to cause the necessary stationery, and other articles, to be supplied, and the necessary printing, to be done for said commission. Section 5. That any said commissioner, examiner, copyist, or messenger, or any person in the public service, who shall willfully and corruptly, by himself or in cooperation with one or more other persons, defeat, deceive, or obstruct any person in respect of his or her right of examination according to any such rules or regulations, or who shall willfully, corruptly, and falsely mark, grade, estimate, or report upon the examination, or proper standing of any person examined hereunder, or aid in so doing, or who shall willfully and corruptly make any false representations concerning the same or concerning the person examined, or who shall willfully and corruptly furnish to any person any special or secret information, for the purpose of either improving or injuring the prospects or chances of any person so examined, or to be examined, being appointed, employed, or promoted, shall for each such offense be deemed guilty of a misdemeanor, and upon conviction thereof shall be punished by a fine of not less than $100. Nor more than $1,000, or by imprisonment not less than 10 days, nor more than 1 year, or by both. Such fine and imprisonment. Section 6. That within 60 days after the passage of this act it shall be the duty of the Secretary of the Treasury, in as near conformity as may be to the classification of certain clerks now existing under the 163rd section of the revised statutes, to arrange in classes the several clerks and persons employed by the collector, naval officer, surveyor, and appraisers, or either of them, or being in the public service, at their respective offices in each customs district, where the whole number of said clerks and persons shall be altogether as many as 50. And thereafter, from time to time, on the direction of the President, said Secretary shall make the like classification or arrangement of clerks and persons so employed, in connection with any said office or offices, in any other customs district. And, upon like request, and for the purposes of this act, said Secretary shall arrange in one or more of said classes, or of existing classes, any other clerks, agents, or persons employed under his department in any said district not now classified, and every such arrangement and classification upon being made shall be reported to the President. Second. within said 60 days it shall be the duty of the Postmaster General, in general conformity to said 163rd section, to separately arrange in classes the several clerks and persons employed, or in the public service at each post office, or under any postmaster of the United States, where the whole number of said clerks and persons shall together amount to as many as 50. And thereafter, from time to time, on the direction of the President, it shall be the duty of the Postmaster General to arrange in like classes the clerks and persons so employed in the postal service in connection with any other post office, and every such arrangement and classification upon being made shall be reported to the President. Third, that from time to time said Secretary, the Postmaster General, and each of the heads of departments mentioned in the 158th section of the revised statutes, and each head of an office, shall, on the direction of the President, and for facilitating the execution of this act, respectively revise any then existing classification or arrangement of those in their respective departments and offices, and shall, for the purposes of the examination herein provided for, include in one or more of such classes, so far as practicable, subordinate places, clerks, and officers in the public service pertaining to their respective departments not before classified for examination. Section 7. That after the expiration of 6 months from the passage of this act no officer or clerk shall be appointed, and no person shall be employed to enter or be promoted in either of the said classes now existing, or that may be arranged hereunder pursuant to said rules, until he has passed an examination, or is shown to be specially exempted from such examination in conformity herewith. But nothing herein contained shall be construed to take from those honorably discharged from the military or naval service any preference conferred by the 1754th section of the revised statutes, nor to take from the President any authority not inconsistent with this act conferred by the 1753rd section of said statutes, nor shall any officer not in the executive branch of the government, or any person merely employed as a laborer or workman, be required to be classified hereunder, nor, unless by direction of the Senate, shall any person who has been nominated for confirmation by the Senate be required to be classified or to pass an examination. Section 8. That no person habitually using intoxicating beverages to excess shall be appointed to, or retained in, any office, appointment, or employment to which the provisions of this act are applicable. Section 9. That whenever there are already 2 or more members of a family in the public service, in the grades covered by this act, no other member of such family shall be eligible to appointment to any of said grades. Section 10. That no recommendation of any person who shall apply for office or place under the provisions of this act which may be given by any senator or member of the House of Representatives, except as to the character or residence of the applicant, shall be received or considered by any person concerned in making any examination or appointment under this act. Section 11. That no senator, or representative, or territorial delegate of the Congress, or senator, representative, or delegate-elect, or any officer or employee of either of said houses, and no executive, judicial, military, or naval officer of the United States, and no clerk or employee of any department, branch, or bureau of the executive, judicial, or military or naval service of the United States shall, directly or indirectly, solicit, or receive, or be in any manner concerned in soliciting, or receiving, any assessment, subscription, or contribution for any political purpose whatever, from any officer, clerk, or employee of the United States, or any department, branch, or bureau thereof, or from any person receiving any salary or compensation from monies derived from the Treasury of the United States. Section 12. That no person shall, in any room or building occupied in the discharge of official duties by any officer or employee of the United States mentioned in this act, or in any navy yard, fort, or arsenal, solicit in any manner whatever, or receive any contribution of money, or any other thing of value, for any political purpose whatever. Section 13. No officer or employee of the United States mentioned in this act shall discharge, or promote, or degrade, or in manner change the official rank or compensation of any other officer or employee, or promise, or threaten so to do, for giving, or withholding, or neglecting to make any contribution of money, or other valuable thing, for any political purpose. Section 14. That no officer, clerk, or other person in the service of the United States shall, directly or indirectly, give give, or hand over to any other officer, clerk, or person in the service of the United States, or to any senator or member of the House of Representatives, or territorial delegate, any money or other valuable thing on account of or to be applied to the promotion of any political object whatever. Section 15. That any person who shall be guilty of violating any provision of the foregoing sections shall be deemed guilty of a misdemeanor, and shall, on conviction thereof, be punished by a fine not exceeding $5,000, or by imprisonment for a term not exceeding 3 years, or by such fine and imprisonment both, in the discretion of the court. Approved January 16, 1883.